Ready? Exercise number 6, Series B, legal matter. Start. An FIR was lodged by Anchal's mother alleging that her daughter left the house on 15th February 2020 with the help of one Arjun and his family. When Anchal was recovered on 4th March 2020, her statement under Section 161 CRPC was recorded wherein she alleged that she left the house out of frustration as she was beaten up by her mother and had then gone to the house of her friend Arjun. It was also alleged that she did so out of her own free will. These statements were reiterated by her in the statement under Section 164 CRPC when she was produced before the CJM Saharanpur on 13th March 2020. The police submitted that as per her high school certificate, her age was 17 years and 20 days, and therefore suitable order must be passed in regards to her custody. Subsequently, she was sent to Child Development Home by the learned CJM. Stop, next para. On being produced before the Child Welfare Committee on the directions of CJM, order was passed for keeping her in the children home under bracket girl bracket out. The present habeas corpus petition was filed on being aggrieved by the said order. According to the petitioner, it was contended that once her custody was denied by her parents, she cannot be forced to be sent to children home against her wishes. However, the learned AGA opposed the petition by submitting that the petition was not maintainable as the impugned order was passed pursuant to the order of the magistrate and the judicial order, right or wrong, cannot be questioned / assailed in petition seeking writ of habeas corpus. The division bench therefore observed that if the detention in custody is as per judicial orders passed by a judicial magistrate or a court of competent jurisdiction, the writ of habeas corpus would not be maintainable. However, after observing that the position was contradicting as held in various judgments, the division bench referred the issues to be dealt by a larger bench. Stop, next para. This full bench, after hearing both the parties, considered it necessary to make certain observations on ancillary issues apart from the main issues framed dealing with cases of elopement of minor girls and their recovery, after which they are sent to children homes. Observing that there was a rise in number of habeas corpus petitions being filed by the parents / guardians or alleged husband for production of their wards or wife who leave their parental houses in runaway marriages. The bench opined that such parents go through agony whereas the couples are on the run with husband being accused of kidnapping and / or rape. Stop, next para. There appears to be a rational and public policy in the legislature not making marriages solemnized in breach of the statutory age as prescribed under the Hindu Marriage Act and the Child Marriage Restraint 18 Act void or voidable. The legislature was conscious of the fact that if such marriages performed in contravention of the age restriction are made void or voidable, it could lead to serious consequences and exploitation of the women who are vulnerable on account of their social and economic circumstances. Both the acts are aimed to discourage performance of such marriages by making them punishable with imprisonment and fine, while recognizing the necessity of protecting marriages performed even though in contravention of the prescribed age as valid and subsisting. Stop. Thank you very much.